Hello, everyone. Tom Fox and Matt Kelly back again for another episode of the award-winning Compliance Into the Weeds. Today, we're going to take up a topic that both of us knew not much about until last week, and that is the Conference of State Board Supervisors, or the CSBS, and their enforcement action involving the company Block, Inc. So, with that somewhat enigmatic intro, Matt, what is the CSBS and what is this enforcement action against Block Inc.?
So, yeah, Tom, thank you. This is the CSBS is actually the Conference of State Bank Supervisors. So it is basically the collection of state bank supervisors across the United States. Every state has at least one banking regulator of some type, although not all of them have that official name. But what is going on here, especially with Block, but maybe even we could talk about some other recent cases, is that the CSBS brought an enforcement action against Block, which is one of those online payment companies. It is a competitor to, I think it's Stripe and a few others, but it is the parent company behind Cash App, which is probably what most people here would know. Cash App is one of those consumer-based online peer-to-peer payment apps, kind of like Venmo, and Cash App had poor practices. Around a couple of different things, actually, but mostly it was around suspicious activity reporting and various other flaws like that for this specific action. So the state banking regulators basically allied their forces into one more powerful unit under the auspices of the CSBS and brought an enforcement action against Block, also known as Cash App. And then they had a settlement just announced late last week at the end of the Biden administration, where Cash App must pay $80 million in fines. It must implement a sweeping new compliance reform program. It must do so under not the tutelage, but they have to hire an independent consultant to review the anti-money laundering compliance program there. That person will make recommendations, which really Cash App and Block won't be able to say no to. And then they have to implement their reforms. They have to make progress reports back to the Conference of State Bank Supervisors, and so on and so forth. So in some ways, that remediation action is not unusual. Some of the other more specific reforms, like you have to have a committee on Block's board that is devoted to compliance, the outside consultant, the remediation plan, the progress reports. We have heard that many times before. But I think, Tom, what is interesting is that this is a reminder. And for everybody listening, we are recording this on the very first few hours of the incoming Trump administration, which has now income, and it is here, that even if the Trump administration walks back or slow rolls or drops a lot of federal regulatory enforcement, there's a whole lot of other states out there that can still do a whole lot of stuff. This is one example. I could give you more, but Tom, that's the nut of the case. Is just it's a AML enforcement action done by a collection of states as opposed to the federal government.
Well, I want to take a step back and try to explain what the CSBS is, but even more specifically, this enforcement action and what it came under. And it came under something called the Money Transition Modernization Act. And that's a single set of nationwide standards that is enforced by this group of state regulators, the CSBS. And the law itself is basically a self-regulation because it was created both by the regulators and industry experts. And they created a model law to which 27 states have enacted in full or in part. And money transmitters licensed in at least one state have adopted the MTMA collectively for about 99% of reported transactions. And the CSBS, through this committee, can investigate individual companies involved, whether that knowledge comes through a whistleblower, a regulatory or rotation, or other. But a group called the State Money Transmission Regulator, collectively known as the Regulators, can go in. And what they did was they looked at transactions covering a period of January 1, 2021 through March 31, 2023 to determine Block's compliance with state and federal laws. And the group involved included the group's regulators from the following states: California, Colorado, Kentucky, Massachusetts, New Hampshire, Ohio, Washington, and the great state of Texas. So we had a wide variety of multi state examiners looking at Block, and they found these deficiencies. Apparently, Block did not have a compliance management committee because that was one of the things that they were required to put in place. The order specified the role of the board of directors. So obviously, the board was not fulfilling its obligation. You mentioned the independent consultant. The independent consultant reports to a group called the executive committee, and the executive committee is made up of the state regulators. So it looks to be a fairly robust oversight for from both the perspective of the independent consultant and Block itself. And as a trial lawyer, what I found most interesting is if there's a violation of this order, any state can bring an individual enforcement action within that state. So that could be a pretty high penalty, or at least a pretty high tripwire for companies to reach if they are involved in any more nefarious conduct or they don't meet the requirements of this order. So, Matt, it seems to be a fairly robust process, a fairly robust investigatory process and enforcement action and continued monitorship slash oversight after the deal was closed. And could this be a model for not only banking regulations, but perhaps other types of consumer or even corporate or B2B regulations?
Well, I don't even think it could be a model. I think it is an example of several other types of enforcement mechanisms like that, where you wind up with collections of states who, somebody once described it as, they are the posse of deputies while the federal government is the sheriff and they can just kind of roll in and round up the bad guys. Well, I mean, it can work that way. Or it could just be a collection of states who take action on their own. And just to widen the lens a little bit here, I'll stick with the CSBS for a moment. This is a group that actually, this is their second notable enforcement action in 2 weeks, because just at the beginning of January, the CSBS brought an enforcement action against a very large home mortgage insurance player called Bayview Asset Management there where they had poor cybersecurity controls, and that led to a big privacy breach. Now, where do the banking regulators enter the picture here? Well, because Bayview and its affiliates, because it owns a couple of loan service operations around the country, the home mortgage industry is also regulated at the state level. It is regulated at the federal level as well, but that does not stop the states from taking their own actions. And sometimes they form these coalitions under the CSBS or other groups, and they bring enforcement actions where this Bayview Asset Management, the mortgage player, they were fined 20 million and had to implement a lot of the same sort of reforms that we just talked about here, Tom. But for anybody who's listening in the insurance world, they also might say, well, tell me something I don't know, because they've been regulated at the state level for decades. And the state regulators typically all work kind of sort of in tandem with the National Association of Insurance Commissions, the NAIC, which adopts these model rules that then state regulators either adopt themselves or states enact those rules as laws. But you could then have also a coalition of states file action against an insurance firm for a large insurance firm or something. I could keep going. We would see state attorneys general. We have seen that they will form coalitions to bring cases against large privacy breaches. So this happened with Marriott International. I think it was last year, where the Federal Trade Commission and a collection of state AGs brought a big privacy settlement against Marriott, where they had a lot of the same things, a big remediation plan, interim reporting. I think it was every other year. They have to have a privacy audit from an outside consultant. That is not unusual for privacy settlements. But again, that thing against Marriott happened, the Federal Trade Commission as the captain and the state AGs as the soldiers following suit. You don't need the FTC to be able to do that, however, and I think in the Trump administration, it's an open question if Trump administration is going to do anything for enforcement. But even if they didn't, the states still can. So you could talk about it with privacy enforcement. You could talk about it clearly with some banking regulations in some banks, the mortgage industry, the insurance industry. You could probably talk about it with other sorts of widespread consumer harm because state attorneys general live and die on consumer protection clauses and enforcement of consumer protection statutes, which makes them look great. Nice headlines. Now the AG can run for senator or governor, something like that. They love doing this stuff. And why wouldn't they? So there's all sorts of ways that this case against Block with the CSBS, this is more emblematic of a wider enforcement wave that has existed for a long time, still existed in the first Trump administration, in the Biden administration, will remain intact in the second Trump administration, that companies, especially larger nationwide companies, will have to think about how do we handle multi-state enforcement.
Matt, we have discussed on this podcast enforcement actions from the state of New York Department of Financial Services and the DFS. But
Mhm.
this is one of the few, if any, I can recall of other states either coming together as a regulatory body to bring an enforcement action or an individual enforcement action around AML. Do you see that we potentially could have much greater enforcement of AML if this group of state regulators starts to get together?
I mean, it would depend on specifically the type of institution. A large bank is probably still going to be regulated foremost by the Fed. A large consumer bank is still going to be regulated primarily by the Office of the Comptroller of the Currency, again, federal agency. However, we should remember that the great case of Wells Fargo and the false account scandal, which the people remember as the CFPB, the Consumer Financial Protection Bureau, kind of busted that into the wide open public view in 2016. Actually, no, it did not. The very first agency to take action against Wells Fargo for fake accounts was California's banking regulators, whose exact name I cannot recall the title of the office, so I'm not going to try. But California was busting Wells Fargo's chops over this in 2011. And, Wells Fargo didn't get it fixed. So eventually, these matters did trickle up to the CFPB. We should remember, by the way, that this enforcement action against Block for the poor AML is the second of two enforcement actions against Block within the last week. The CFPB did act in conjunction with several other states, file a wholly separate enforcement action against Block for poor anti-fraud customer service. What are we going to see with CFPB enforcement? I don't know. What are we going to see with the Federal Trade Commission and data privacy? I don't know. But if we don't see much enforcement at the federal level, that is going to create a vacuum. And some states, at least, will be more than happy to rush in and fill that vacuum. They might rush in and fill it in different ways. I could easily see that maybe the state of Texas and the state of Massachusetts might have very different ideas about different types of consumer protection actions that might happen. Tom, I'm thinking more like, the Consumer Products Safety Commission. And I don't know that we've ever talked about that, you and I, in 9 years of doing that podcast. But if the Consumer Products Safety Commission suddenly decides it's going to spend the next of its 4 years sitting on its hands, would states maybe step in to take some sort of actions around consumer product safety? I mean, they could. The state attorney generals certainly have wide discretion to try. They've got a lot of political incentive to try. But the point for compliance officers is, for example, you already have a really difficult time with state data privacy laws, which are governed individually in the United States. So you got 50 different state privacy laws and a couple of federal rules around privacy, but no federal privacy law. And I do not think that will change in the Trump administration. So take that idea, that frustration, which we all know of different state privacy laws, and to put that on steroids and put it on, 50 different state enforcements about what? Everything. You could have different standards of cybersecurity, different standards for AI, different standards for discrimination. We could go on and on. The key principle here is, how does a compliance program prepare for that? How do you work with the legal department to prepare for that, or outside counsel? What if different outside counsel in different jurisdictions give you different advice? So you could sketch out a whole lot of really difficult scenarios, I think, all predicated on the open question of whether the Trump administration's federal government will ever take its enforcement duties seriously. And, there's a lot of good reason to think that maybe no, they won't. And, what happens after that?
Well, thank you for teeing me up with the question of what does this mean for the compliance professional today? So, how do you prepare for a multitude of enforcement actions? In the following manner. Number one, you have transparency in your compliance program so that if a regulator comes knocking, and now as we know, whether that's a federal government regulator or a state regulator or a city or county regulator, you can show them the results of your compliance program and how you have followed some program, whatever that is. Number two, your board of directors has a compliance committee or within the audit or other appropriate committee has some sort of risk management function for the risk of your organization. If you're a money transfer firm, your greatest risk is money laundering. It's like if you're a Bluebell ice cream, your greatest risk is food safety.
Mhm.
Have a board oversight. And then three, have a management level committee looking at compliance and risk. So having those in place, it seems to me, is going to protect you from whatever regulator comes knocking, particularly if you follow a standard 8-point compliance program. But let me even not hypothetically, when you spoke about state regulators, even the state of Texas has brought suit for forever chemicals, and we're the most chemical friendly state in the nation. So we could have very robust enforcement action from a wider variety of state regulators. I guess the other thing, Matt, is I wanted to maybe explore a little bit is this. You've talked about informal groupings of states. You've talked about states attorneys generals who's come together. Are there other s- states, organizations that have banded together beyond the CSBS or other groups that are more formal in nature that have done something like or create a proposed template for a law or have a proposed template for a compliance regime with a management committee and board oversight that are lurking out there that maybe we haven't explored before?
I mean, the honest answer is I do not know. However, a couple of them do come to mind is, for example, the insurance regulations are done at the state level in the United States. I could imagine in the future that there would be more states banding together, particularly Democratic led states trying to combat something the Trump administration is doing, maybe around environmental protection. I could easily see them at least trying to do that. Would it work? I don't know. I'm not a lawyer. But, the obvious one is banking because every state does have a state banking regulator of some kind. There may be, I could imagine people might try this around labor standards. They might try it around pollution standards. Again, I don't know exactly what the legal mechanisms would be for this. I would bow to the wisdom of tort lawyers out there who might be smarter than I about it. But I mean, I get back to more the fundamental principles of will there be a vacuum of enforcement compared to what we've been used to in the United States? Probably, yeah. Will some people like it? Yes. Will some people try and take advantage of it? Yes. But different groups will define take advantage in different ways. And there will be plenty of state regulators who will see a vacuum and try to rush in to fill it, probably because they believe that if the federal government is abdicating its responsibilities, somebody somewhere has to be the responsible party. But, I could easily see that. How does that work out in a state versus federal jurisdiction kind of disputes? I don't know. Tom, I would add one more thing, though, getting back to the compliance programs and what you need. I could easily see that this is going to pose some really tricky policy management challenges for you and regulatory change management challenges for your program. If you're a large nationwide company and you have to keep track of 50 different states and come up with potentially 50 different policies to handle these issues, that could be really quite a complicated thing. I know there are plenty of vendors out there who would say this is why God invented artificial intelligence and automated regulatory change management. There will be people out there saying that they have a solution for this need. And who knows, they might even be telling the truth. But the problem that they are pointing out is going to be substantial. I would kind of liken it to the EU Whistleblower Protection Directive, which exists across all 27 EU member states, but each state then takes the basics of the whistleblower directive and can do more with it if it wants, or can tailor it in certain ways. It's kind of sort of like that. We're going to have an issue: data privacy, fair lending in mortgages, consumer protection, data protection, artificial intelligence, who knows what. And if we lack a federal standard, then states are going to adopt their own standards, and you'll have to know what that standard is, figure out which of your policies and controls do and don't match that standard. If they don't, we have to bring them up there. And then you have to start thinking, well, do we really want to do this with all 50 states? Should we just pick the most onerous state standard and comply with that, so that we will, by definition, comply with everything else? I think in many ways that means just do what California tells you, because they're always at the forefront of pretty much every compliance demand and burden. But, it'll be stuff like that. And I don't know what the right answer is, but I do know that's probably going to be the question you have to ask, at least in 2025 and potentially beyond.
The other twist I'd like to throw in is the DFS, because they have had some very robust regulatory actions, both on their own and together with federal authorities over the years. But they've also released a large amount of compliance information, or at least frameworks where you can start to put a compliance program in place. So if you're a broker dealer, if you're an insurance company, they have put together not simply AML programs or general compliance programs, but also data privacy, data protection. So I think there's a fair amount of frameworks out there, even from the state level, that companies can utilize. But I think the DFS may become very active over the next 4 years.
It potentially could. Then again, we get into, if the state regulator of New York is getting really aggressive, are those aggrieved parties going to complain to Donald Trump, who's going to try and hold up the state of New York for something or others, get them to back down? I think that's, an issue we can discuss another day, but the ways that Donald Trump will try to strong arm states into doing his biddings, regardless of what their political leaders and state